Good afternoon, everyone. It is February 24th, and it's 4:32 in the afternoon, and we're about to convene the joint committee on judicial retention. So I would like to start. I know Judge Grierson knows most of us from one way or another from being around the State House, but I would still like to go through some introductions. It is my understanding that everyone is looking at a different screen. So I guess the best way to do this, if I would just call your first name or refer to you actually by your title, and then you can introduce yourself to the two judges here. Does that sound okay with everyone? Okay. So Senator Nica, you are to my immediate left, so I will start with you.
Okay. Alice Nitka. Welcome, everyone. I've met Judge Waples and, of course, Judge Grierson previously, so nice to see them both again.
Thank you.
Thank you.
Representative Shaw, you are to my immediate right.
Thank you, Representative Toriano. Hi, I'm Butch Shaw, and I have met Judge Grierson before, so hi, Judge. I have not met Judge Waples, and the pleasure is mine. Thank you.
Thank you.
Okay, Representative Knott, you are directly below me.
Okay. Hello, I'm Representative William Knott from Rutland City. I'm currently serving my second term in the House Judiciary Committee, where I've had numerous occasions to hear from Judge Grierson. And it's nice to make the acquaintance, Judge Waples.
Thank you.
Thank you.
And to his right, Senator McCormick.
Hi, I'm Dick McCormick, and I represent the Windsor County Senate District along with Senator Nitka. And I do know Judge Grierson, and I'm pleased to meet you, Judge Watt.
Likewise, thank you.
And Representative Benny, check that, Senator Benny, sorry.
You did it again, Chippy, you did it again. Judge Waples, good afternoon. I'm Joe Benning. I represent the Caledonia Senatorial District, which is all of Caledonia County and the 6 northeasternmost towns in Orange County. I believe we have met before. I serve on Senate Judiciary, and I don't know Judge Grierson at all. Good afternoon, Judge.
Good to see you, Senator Benning.
And to his right, Senator Hardy.
Thank you, Mr. Chair. Good evening or afternoon, Judge Waples and Judge Grierson. It's good to see you both and meet you, Judge Waples. I'm Senator Ruth Hardy from Addison County.
Thank you.
Nice to see you, Senator.
And to her right, Representative Colburn.
Hello, I'm Representative Selena Colburn from Burlington's Chittenden 6-4 district, which is where UVM and the hospital are. If you want to orient yourself to Burlington, and as others have said, it's very nice to meet you, Judge Waples. Do you say Waples or Waffle?
It's Waples. I like to tell people that it rhymes. It's perfect for Vermont because it rhymes with maples. So yes, it's Waples. It's a pleasure to meet you.
And you as well. Thank you. And nice to see you, Judge Grierson.
Good to see you, Representative.
Judiciary Committee.
And we'd like to introduce our alleged counsel, Eric.
Nice to see you both, Judge Waples and Judge Grierson. I know we've communicated a lot over email recently and in person, Judge Grierson, but it's good to see you here. Welcome.
Thank you.
Thank you, Eric.
And our committee assistant, Peggy.
You're muted, Peggy.
Muted.
She finally gets it.
Yeah, I'm used to being muted. I'm Peggy Delaney. This is my 5th year as committee assistant for judicial retention, and nice to meet you, Judge Waples. And I know Judge Grierson. I work with him all the time. So if there's anything I can do for you, let me know.
Thank you. It's nice to meet you as well.
Thanks.
Thanks, Peggy.
Thanks.
And I'm the chair of this committee, and my name is I'm Representative Chip Toriano. I represent Caledonia 2 District, and I am well acquainted with Judge Grierson, and welcome, Judge Waples. It's a pleasure to meet you.
Likewise, thank you.
So we are here tonight to hear from our two judges that are present with us on this Zoom meeting. And they are going to give us prepared statements and be prepared to answer some questions from the committee regarding why they would like to seek retention as judges. And Judge Grierson is the administrative law judge. Is that still the title, Judge?
Well, no, the new title is Chief Superior Judge, and that was brought home to me, if not more so by the response in the surveys. So I'll get into that in more detail, but the correct title is Chief Superior Judge, and it was not my idea, but again, I'll get into that later.
I thought I read that somewhere.
Yes, you did.
Okay, so we will start with Judge Grierson. Welcome, Judge Grierson. Again, you are familiar with most of us on this committee. And if you can just, the mic is yours, as they say.
Thank you very much, Chair Troiano. And I guess I'll start at the beginning by saying thank you to you, Chair Troiano, as well as the other committee members for this opportunity for me to address you and in support of my request to be retained for another 6-year term as a Superior Court judge. We all know how unique this experience is to participate in these proceedings by remote means, by Zoom. But I have to say that this experience, the retention experience, at least for me, is even more difficult. I'm used to appearing in front of many of you by way of committee and certainly talking with judges, but the retention committee in this process is one that I wish it could be in person, but it's not. So again, I want to thank the committee for giving me this opportunity to speak. It has been my honor to have been appointed to the bench in 2004 and to have served the Vermont judiciary as well as the state of Vermont. And I look forward to being able to continue in that service. You know, in the 16 years since I was appointed, I will tell you that I still relish the challenge, the sometimes frustrating aspects of the position, the excitement, if you will, but hopefully I still conduct myself with the same humility now that I had when I was first appointed. And I recall when I received the notice or when my appointment was announced that two messages stood out for me. One was from a judge who had only been on the bench for about 2 years, and another from a judge who had been on the bench for about 20 years. And I knew both of them, had appeared in front of them, respected them. They both sent a simple, brief message, and that is, welcome to the best job you'll ever have. And I will tell you that over the 16 years, that has proven to be true. And as I said, I still relish the challenge that this position brings every day. It has been obviously an extremely interesting year for the last year, continues to be so. And I find myself appearing before you today in a somewhat unique position. I still have, I feel, I'm sure, some of the same apprehension that a judge who appears before you for the first time feels. I have been through retention on 2 occasions, but this has a different feel for me, probably because of the position that I now hold within the judiciary, in which, as we referenced, was a topic of some comment in the surveys. And I'll get to the surveys in a minute, but the uniqueness for me and maybe what the committee will have to consider is the fact that when I was last before you, I had 10 years on the bench to support my retention. I'd only been in this position of Chief Superior Judge for about a month. And obviously the position was new to me. All of you were new to me and just beginning to form the relationships that now exist. But it's been for me an interesting and challenging 6 years. And I would like to continue in that role. I say that I feel like a judge who is coming before you for the first time, because as I look at the survey results, which I know play a significant part in your decision-making, at least in my case, the best term I could come up with was a dearth of results. When I first saw the, I guess the quantity, if you will, of the results, I was reminded of the old song, "Don't Get Around Much Anymore." But I think as I thought about coming before you today with that in mind, and the change in my role and the change in my work with the judiciary and with the legislature, I came to the conclusion that, quite frankly, the members of this committee are in the best position to evaluate my performance over those last 6 years. And I say that recognizing that you can follow the same survey, if you will, some of the same questions that you ask of attorneys and court staffs of the judges and magistrates that are coming before you. You can apply those same questions to me in terms of my performance in front of your committees and in front of you. And just by way of example, when you look at the survey results or the questions around, does the judge come to court adequately prepared for conferences and hearings, I think applies equally to my appearances in front of your committees. Do I encourage settlement and alternative resolutions? I'd like to think that I do that. I don't make bench rulings in the hearings, but I would like to think and would ask you to consider whether my oral and written communications are clear and logically stated. And in this category anyway, finally demonstrates knowledge of substantive law and procedure and evidence. Because even though I come to the committees as a judge, I'm often, I think, asked to testify in different capacities. Sometimes it's almost as a party, providing facts to various committees so that they can make decisions. Other times I'm asked to provide opinions, not necessarily legal opinions, but opinions on how a particular bill may impact the judiciary from an operations or administrative standpoint. And I think I would like to think, and I would suggest that the committee, in addition to the survey results, that you should feel free in consulting with each other and evaluate my performance, if you will, my conduct before your various committees. And I think you can even extend that to, you've mentioned, and by way of introduction, Representative Troiano, Eric and Peggy Delaney. Their legislative staff, and as Eric and Peggy have both said, I have a lot of contact with them. And again, I think the committee should feel comfortable in reaching out to Eric, Bryn Hare, Michelle Childs, Peggy, and any other administrative assistants to get their opinions. I think that's why, as I stated earlier, I find myself in a somewhat unique position in coming before you, having in mind the role I have played in the last 6 years with the judiciary. I'll briefly comment on the survey. There weren't a lot of results. There was obviously one individual who was not satisfied with my performance, either as a judge or as the chief superior judge. And I just want to make a couple of corrections to those statements. The title is chief superior judge. It is an appointment by the Supreme Court. They made the change in the title before I took the position. I don't decide my salary. others decide that. I wished I could come to you and tell you that we have had tremendous success in restarting jury trials, but at this point, we are still struggling to do that, and we hope to have our first trial, jury trial, later in March. We're still awaiting the results of some structural evaluations, but that the jury has been notified. And the final piece that was in that comment was about rotation. And I think most of you may be familiar with the process, but on an annual basis, I have to decide where to assign judges throughout the state. And in conducting that process, matter of fact, I'm just now starting it this year for next year's rotation. The rotation year starts in September of every year. And the requests go out to the judges, and they are asked to provide me with three choices of their own of where they would like to sit, either by way of county or divisions, criminal, family, civil divisions. And I have to assess all of those requests, and I try to honor one of the three requests. I think I do a pretty good job of doing it, but I will confess that there are times when I cannot honor any of the three requests, and the person is assigned perhaps somewhere that is not on their list. But it is done after a discussion with me. It sometimes is driven by the needs of the judiciary. Sometimes it's filling vacancies. Sometimes it's a skill set of a particular judge that I need in a certain area. And I'll be glad to go into as much detail as any committee members want. But suffice to say that there are many times when I have to assign judges to areas where it is not their first, second, or third choice. So it is not done through favoritism. I would conclude by saying that I hope you'll take into consideration not only survey results, but your own experience with me. And I guess I would leave you with the thought that as I look through the comments from the staff members, there's apparently someone out there who's been around as long as I have and said they've known me for more than 40 years, which goes back quite a ways. So I guess I would ask you to consider their recommendation with perhaps more weight than someone who has been in front of me for 3 to 6 to 10 or 20 times. I'll close with this thought, though, and it's really speaking for some of the judges and magistrates who may come behind me. When I said that I feel some of the apprehension of the judges who are appearing for the first time, it's not just, and I would ask you to consider this when you're questioning some of the other judges, it's not always just appearing for their first retention, but keep in mind where they are in the transition from being an attorney to a judge. I was told when I first took the bench, and again, that's proven to be true, it takes 5 years to feel comfortable in the role of a judge. And so many folks coming before you are still in that transition. So that won't apply to me except in my transition to the chief superior judge. But beyond that, that's all I have for comments, but I'm glad to answer any questions about anything that I have said or have not said.
Chip, you're muted.
I thought I muted myself. Thank you, Judge. We will give each member of the committee an opportunity to ask questions that they may have. And I think we'll start with Senator Nitka, who is again, right next to me here on the window.
Alice, you're muted.
Yeah, you're also muted.
Thanks for doing all the work that it takes to do retention. I really appreciate it. And I think that you are in a unique position in terms of, you're, as you say, assigning people perhaps where they don't want to go, having them fill in on other cases where they might not like to be. But overall, I was surprised myself for some of the negatives that you did receive, and wondered if some of them were from the same person or not. Who knows? Although you may have figured out more than I have. But I'm wondering, is there a particular situation that seems to get people more than others that might make them come through with the negatives, with negative comments or thoughts?
Senator, I'm not sure I do know more than you with respect to why the comments. It did appear to me to be one individual, on a couple of occasions, two individuals who had those comments. It just struck me, and I could be wrong, that had to be someone who was extremely dissatisfied with. If they only appeared in front of me a few times, it must have been a case that I handled that did not turn out the way they wanted. I'm speculating, obviously, but that's what I was trying to say earlier, that the concern, it's not that I'm not concerned about the negative comments. I expect them. When I say expect them, we're dealing with people who bring their problems to the court. We have to decide. And when we make a decision, obviously one side is going to be leaving the courthouse not as content as the other side. And oftentimes, there weren't that many people that responded anyway. And so the committee understands. I tried to continue to sit for a day in court after I took this position, but I found that I couldn't. The only day I had was Monday, and that was catch-up day. So I do continue to sit in courts once the session is over. The judges and courts have to contact my office when a judge is sick or going on vacation or is taking personal time for me to find someone to cover for that judge. So I think what you're seeing, keep in mind that's 18 months before this retention committee took place. Mm-hmm. I would have sat in individual courts for probably no more than a day at a time, but I tried to take advantage of the opportunity, since they have to call my office, to sit where I could, because I think the experience that I continue to have as a sitting judge is helpful when I'm in front of you or any of the other committees, so that you understand that I am still sitting and still making the decisions that we're talking about. And what I've tried to do over that time period in the summer and fall is sit in as many different dockets and as many different courts as I can. So I really don't have an explanation for this person's comments. I wish I did, but I don't know that it's the same person who had the questions about my role as Superior Court judge, but I have to believe that some of the negative comments are attributable to the same person. Obviously, they are not very happy with the way I've conducted that office. That's the best answer I can give you.
Okay, thank you. On one other note, I would like to say that I appreciate when you're coming into our committees, the variety of issues that we ask you about, and you're looking through it all and trying to appreciate where judges are in terms of looking at what we're proposing as laws and how they really might not work. And I really appreciate the fact that you have knowledge of so many different areas and can tell us why this proposal we have wouldn't work. And I think you've done an excellent job at that. So thank you.
Well, thank you. But remember, sometimes I tell you they will work too. It's not always negative.
Thanks. That's all for me, Chip.
Okay, thank you, Alice. Representative Shaw is next to me on the other side. So you have some questions for the judge.
Oh, thank you, Mr. Chair. So, Judge Grierson, thank you for pointing out the negatives as well as the positives. But I do would ask you one of the negative responses to help me understand what your responsibility is on reopening jury trials, and
Sure.
whether or not you are this is your lone decision, or are you working in concert with the health department and the governor's staff?
The short answer, Representative Shaw, is that although I have a significant amount of authority and discretion in that area, it is not a single decision on my part. I work. It started out with the Supreme Court creating what they referred to as a jury restart committee. And they went through and came up with, I want to say, about 25 recommendations. The emphasis originally was on restarting criminal jury trials because of, quite frankly, the detained population and individuals are being held for lack of bail or no bail. So the emphasis was on that. And what they directed me to do as a result of those recommendations is work with the individual courts, presiding judges in the various courts, to determine which courts, and I'm talking physically now, were able to conduct jury trials. What we have found, and in doing that, let me go back for a minute. The state courthouses, for instance, in Rutland, the McCaffrey courthouse is a state courthouse as opposed to your county courthouse. We work with BGS in the state-owned buildings. They don't have any authority in the county courthouses. So as we're looking at those buildings, and that was the first step in the process, because we have to find a building that is physically able to accommodate all of the requirements that we're all operating under, the masking, social distancing, the Vermont Department of Health recommendations and guidelines, the CDC. We've also hired our own consultant, Dr. Aaron Bromage out of the UMass Dartmouth, who was consulting with half a dozen or more New England courts, as well as other businesses and entities nationwide. So we brought a lot of people in to assist us in this process. And although I do have, as I said, significant authority, I don't have the final say in this sense. Once we're satisfied, based on the reports from the engineers, BGS and so forth, that the buildings can accommodate a trial, then I will work with the presiding judge, myself and Terry Scott, who is the chief of trial court operations, and Pat Gable, to make sure that the court has the staffing for a trial. And I think the best explanation I can give you, example, is the Wyndham courthouse in Brattleboro is where we hope to start our first jury trial. But in order to conduct a jury trial in that courthouse, which is one of the more modern ones, I'll say, it will literally use 3 courtrooms to conduct a single jury trial in order to meet the social distancing requirements and all of the other factors that come into play. We've had to rearrange, if you will, reconform the courtroom so that what you're all used to seeing as a 12, 14 person jury box, we only have 3 people in the jury box. We've scattered the rest of the chairs throughout the courtroom to achieve that social distancing. We've moved counsel table. We've had to switch the location of witness chairs and recorders. So there's a significant amount of effort that has to go into this, and clearly I have to be working with the court staffs and the presiding judge in any particular county. We're still undergoing an evaluation of buildings in order to determine whether they can accommodate a 12-person jury or a civil jury. There are some courthouses, for instance, that probably could conduct a 12-person jury, but they don't have the infrastructure to bring a person in custody into the courthouse. They don't have a lockup. They don't have the security that's necessary. So we have to look at what buildings are ready now or can be ready with minimal improvements, and what kind of trial can they accommodate. So it's a job that a decision that involves an awful lot of people, including myself. And in the final analysis, I do have a significant amount of authority under the recommendations that the Supreme Court came down with.
So would it be fair to say the other jurisdiction, the person that responded to, they have different standards than we do in Vermont? Therefore,
in other states?
Yes.
Well, for instance, I get involved with a number of groups. New Hampshire has, I think they've had, I'm going to say about a half a dozen trials. There are other states, I think Connecticut, Rhode Island, have not had any trials. So it is so individualistic on the building and the resources available to those courthouses. The New Hampshire one, I'm in close contact with the judge in New Hampshire, who is, I guess you'd say, the equivalent to my position. They have some very large courthouses, and those are the ones that they've been able to conduct trials in. Massachusetts, for instance, has had little or no jury trials down there. And I believe my last meeting, I believe in Rhode Island, Connecticut, have not had success. The federal courts here in Vermont have attempted to have trials, but without success, to the point where, unless Judge Waples can correct me on that, they've had limited success. They may have had one or two trials that they have decided to wait until the vaccine is more readily available. They've struggled. So even the courts, states, if you will, Representative Shaw, that have had trials, it's not as if anyone is conducting business in the normal course of events. Even New Hampshire, we were ready to go in the fall with Wyndham. But when the increase in numbers and virus cases came up, we had to take a second look. I mean, we're not forcing people to come into court when it's not safe. So we were ready to go December 7th, but we had to suspend operations at that time. And when we did that, it was in part with consultation with this Dr. Bromage, and he was recommending and advising the other New England states the same way. And to the extent that courts were conducting trials, they stopped them for the same reasons that we have. But our biggest obstacle right now is in determining which courthouses can accommodate the number of people that it takes to conduct a trial. We're also exploring other options. The Chief Justice recently designated Justice Carroll to look into the possibility of conducting completely remote or virtual trials, civil trials. And so we're looking into other options.
Thank you, Judge Grierson, and thank you, Mr. Chair.
Okay, thank you. So we will go to Senator McCormick. You have some questions for the judge?
Yeah. First of all, just I think we owe it to any citizen who comments to not brush them off. We owe it to them to look into their complaints. But having said that, I also have always had a problem with the anonymous complainer. The idea of facing your accuser is usually seen as a very basic right. So I reserve judgment on any complaints. which is not to say I'm brushing them off. I think they have to be considered, but I reserve judgment. I do worry about the old adage that justice delayed is justice denied. And to back up one cliche with another, where there's a will, there's a way. If we regard this long a delay on jury trials as simply non-negotiably unacceptable, I'm wondering maybe hold trials out in the field somewhere, but one way or another, we would do it. What do you say to people who have been waiting too long?
Well, they should. Look, Senator, I agree with everything you've said, whether it relates to I'm certainly not brushing off the adverse comments that were put in the survey. Start with that. I agree that they need to be addressed, and some of them, it would be more helpful to be able to address them in person, but we can't. With respect to the jury trials, I recognize the rights of individuals to have their trials as soon as they can. We are dealing with a set of circumstances that we've never had to address before. And we literally had to close our operations in mid-March and operate only on an emergency basis from March until June, and then gradually restarted. The Supreme Court's first priority was this criminal, the custody, the individuals who are in custody. That has been their priority. And we began that process of standing up a trial when it looked like last fall. I have to tell you that the information that was available to us at that time was that the Wyndham Courthouse was the one, and because of its size and structural elements, quite frankly, the circulation, air circulation and airflow system is what's key to opening up these courts. That was the only one we could identify early on as being a likely candidate. We're finding that many of our courthouses don't have adequate air ventilation. So that was the first step. The next step was that to bring in a jury, because of the COVID circumstances, we had to respect the rights of inviting the public in to perform what is otherwise a civic duty. If they were concerned about COVID, we had to respect that. So we doubled the size of the normal jury pool we were going to bring in. But in order to do that, in order to address that number of people, we went from what would normally be a jury pool of 150, we increased it to almost 300 people. But you need time to process all of those requests. So we then took a normal delay between notice to jurors, first notice to jurors, and coming into court, which would normally be 6 weeks. We expanded it out to 8 weeks. And so that brought us into the late fall. And is that, the process is one where each step of the way, it's like reinventing the jury trial process because of the pandemic conditions and what we had to do with these courthouses. So would I would like to have moved sooner than this? Of course I would. I don't think anyone should be detained any longer than is necessary. We are trying to get these courthouses up. We expect that we will be making significant progress over the next few weeks to be able to get more courthouses up. But it's not as if we could open the doors. We have had very few. We have made an attempt since the numbers increased in the late year, the latter part of the year and into the holiday season, of not encouraging and not providing for in-person proceedings because of the risk in the community. And that's what's in part had to guide our decision making. So I share your concern about justice being delayed. And we are doing what we can to get there. And I'm optimistic that the worst is behind us.
Yeah, well, to finish up this round right now, just say, I was thinking a few weeks ago about what are the job situations I have hated most in my life, and what do they all have in common? And it's always being held responsible for something over which I have no power. And I understand that the nature of the COVID thing has just imposed situations on us that for which there is no good response. I do understand that.
Yeah, what's been interesting, well, interesting is a mild word, I guess. What's been challenging is just when you think you understand what the parameters are, they change. Either the guidelines from the CDC or the recommendations we're getting on masking and social distancing. But I think that, again, using the Wyndham Courthouse as an example, that's what we're talking about in trying to get trials started again. 3 courtrooms to conduct essentially one trial. And obviously not all courthouses are going to be able to accommodate that. So we're going to keep at it, Senator. Thank you.
So that's all I have for this right now, Mr. Chairman.
I think you're muted, Representative Troiano.
Yes, Representative Colburn. You could read my lips, apparently. Do you have some questions for the judge?
Oh, do I?
Yes.
Yes, I did. I have a question.
You are.
I just wanted to note before my question that this question of jury trials is one we spent a lot of time talking about in the House Judiciary Committee at the start of the session, because I think there are many of us who share the concerns there. And I have no doubt that there have been similar questions with our Senate counterparts. And we've had a lot of discussions with Judge Gerson and other players in the court around this, and just want to note that, you know, other witnesses, the state's attorneys, and even the defender general really kind of all said the same thing, that there's just been no clear path forward to do this safely in the facilities that we have and with the kind of legal framework that we have in Vermont. And so I just wanted to acknowledge that this is a much bigger, you know, Judge Gerson is in a role of responsibility here, but it's a much bigger question, and it's one that all of the players, at least that we've heard from in our committee, have really acknowledged the same hurdles that Judge Gerson has shared with us. My question, though, for you, Judge Gerson, is just, I think, you know, this is just my 3rd year on this committee, but more than any other judge I've seen come before us to date, you have such a range of responsibilities. There's the work that you do with us in the legislature to help us interpret and understand the impacts of proposed legislation on the courts, and the work that you then often do to roll up your sleeves and help us make that legislation better, working with legislators and stakeholders. There's the work that you do coordinating and supporting other judges, and we've often seen you in this committee in that support role for other judges who are going through this process. And then you talked a little bit about some of your strategies here, and then there's the work you do actually sitting on the bench and presiding over cases. And I'm just wondering how it seems like a lot of different sort of realms of responsibility to juggle, and I'm wondering how you move through those different aspects of your work, and kind of, you told us a little bit about how you stay current on the bench, and I really appreciated that, but how you how you kind of manage all those transitions and are able to just manage the workflows and also stay current in each of those different realms.
You know, Representative Colburn, I don't know. Look, I have the support of the judges. I meet with them on a regular basis. I keep myself informed of what's going on from their perspective. I obviously spend a lot of time in the legislature. I spend a lot of time with the Supreme Court with their initiatives, their directives. If you remember my initial comments that I enjoyed the challenge, and I also mentioned the frustration. So I don't want, it's a challenging position, but I enjoy it. And I'm sure there's some that say I'm not managing this as well as you've expressed it, but it's just, it's an extremely interesting, challenging position. And I guess I enjoy what I'm doing, so it makes it easier. Not sure how else I can respond to that, but it's a challenge.
I appreciate that, and that's a question I had kind of at the onset, and I think in some ways you had answered parts of it earlier. So
yeah, I'm not. Hopefully that answers your question, but if it doesn't, I'll keep trying.
Yeah, thank you.
Thank you, Representative Colburn. So I would like to move to Senator Hardy. You have some questions for the judge.
Thank you, Mr. Chair. And thank you, Judge Grierson, for being with us tonight, despite the strange circumstances. I was, in reading your file, it felt thin to me, not only because there are not a lot of responses from the surveys for obvious reasons, but also because you're not sitting in a courtroom and issuing decisions. The written work was also, shorter, and I didn't get a feel for the way you make decisions like I did with the other judges reading their decisions. Mm-hmm. I wish we'd been able to have the foresight to get more information. I don't know if it's appropriate, but to get some kind of survey responses from the judges that you oversee, because I think they're the ones that, you work with regularly also in the Supreme Court to hear their sort of survey responses, 360 analysis of your work. You obviously have a very unique position within the judiciary, and your reputation is being very smart and competent and very good at getting answers for people, and I appreciate that this past year has been extremely difficult for someone in your position, as it has been for almost everybody on the planet. But I do, and I, as Representative Colburn said in her committee, she's heard a lot of testimony about courts reopening, and that everyone sort of is in agreement about the fact that it's challenging. But as a member or former member of the Education Committee, we went through the same thing with how do we reopen schools, and they have some of the same challenges with old buildings and lots of people and et cetera, and how do you do it? And we were able to do it because we prioritize being able to have some kind of in-person education. And it hasn't been perfect, and there've been challenges for sure. But that was the sort of parallel that I saw, was we were able to open schools, but not courthouses. And that's, I think, unfortunate, given, Senator McCormick's comment about justice delayed is justice denied. So I don't know that you have any more to say on that, but that was just sort of my impression.
Well, I'll let you finish.
Go ahead. No, go ahead. I have another question, but go ahead if you want to respond to that.
So two things. One, I would welcome a survey from the judges of my performance. That may be something the committee wants to consider going forward for this position. I mean, maybe you want to do it now. I'm saying that might be a way. As I was preparing for this session today, it occurred to me that because of the uniqueness of my position, that it's, you know, you have to evaluate it differently, and maybe that is a way of getting information either for this session or in future. So it's probably a good idea. And for my own part, I would certainly welcome it for the same reason that judges, you know, nobody likes to read the adverse comments, but you learn from those. That's been my experience. So even though there's few people responding to my surveys, I take to heart what they're saying. The good is the bad and the ugly. I guess I would remind the committee that the real issue, we are conducting hearings. The courts are open. It's jury trials that we're struggling with, but we are open and have been open. We have expanded greatly our ability to conduct remote hearings. It's not as if the judiciary was saying you can't come into court. We are finding other ways of being able to conduct proceedings in a safe manner, and having in mind, you know, as I said, we continually monitor what's going on in the community with the virus. And when things turned really bad towards the end of the year, we had to increase remote hearings. But so we are conducting hearings. Where we're really struggling, as it's obvious, is in jury trials. But keep in mind that jury trials involve the largest number. Where then, instead of people who have to come to court because they are either the subject of a criminal proceeding or they have chosen to come to court to resolve their disputes, when we're talking about jury trials, the largest segment of people coming to court are the citizens, and there's a large number, and that's what we have to be able to accommodate as opposed to our day-to-day hearings. So I don't want anyone to think that the courts aren't open. And as a practical matter, and I've said it before, if there's a silver lining in this pandemic, it is our ability to have expanded significantly our ability to conduct remote hearings. And a lot of that will continue to some degree when we get back to normal, whenever that normal is, because Vermont, obviously, there are limitations on people being for transportation. And so we expect that many of the areas that we have had to expand into will continue for those reasons. So we continue to explore ways of conducting hearings. We have situations, quite frankly, even if our courthouse doors are open, that many attorneys and litigants do not want to come in to the buildings. And so we have, I think we've done a good job of expanding through technology, through resources made available through the COVID relief funds and from the legislature taking steps to make sure we have the resources to be able to do this. So.
Okay, I appreciate. I feel like I have an echo. I appreciate that, Judge Grierson, and your point is well taken that it's just the jury trials, it's not everything else. And I believe another judge that we're reviewing, I believe it was Magistrate Hoyt, but I could be remembering incorrectly, who talked about your expanded ability to do remote things and how great that was. So I really appreciate that you did not waste this opportunity to expand your ability to serve the citizens of the state in different ways. And that's really great. The other question I have, and I've been mulling in my head how to ask this in this weird format. It would be a lot easier if we were in person and less awkward. But you did ask us all to rely on our own personal experiences with you in your role with the legislature and reflect on that and ask our colleagues. And a couple of the negative comments that were in the your surveys hit home for me and my interactions with you. I guess it would be helpful to hear your thoughts on the comment specifically, not the very really long comment about your role as Chief Superior Judge, but the one that was more about how you often weren't good at listening and were a little dismissive. And again, I apologize for the bluntness of this question, but it over Zoom, but that I just like to hear that a little bit more, because I think it's a question about temperament, judicial temperament, and that's a really important part of what we're supposed to be evaluating. So just wanted to hear your comments about that.
I think what's hard, Senator Hardy, and you shouldn't have any qualms about asking the question. I think that's why we're here. So I understand that part of it, but you know, the hard part about the anonymous responses is I don't know how to respond. You know, to an individual comment like that, because I don't know what the circumstances were that led this person to come to that conclusion. I wish I had a better answer for you, but to ask me, look, I pride myself on being, you know, on being a good listener and listening to people. I think one of the most important things a judge can do in making a decision is not the decision, it's how you explain the decision to the individuals in front of you, so that they understand, even if they are not the ones that are leaving the courthouse feeling good about the result, they will understand how you arrived at that point. So I always tried and still try to make sure that I convey not only the decision, but why the decision. You know, as I said before, people coming to court, they're asking us to make a decision, and we do that. I mean, that's what we're supposed to do. My concern is in a survey like this, for instance, I think there were only 20 people that responded. I don't know how to answer that other than saying, not only me, but any judge that's coming before you in this retention process makes thousands of decisions day in and day out. And so I don't have an answer to this person. I don't, no one likes to see those comments, but I do not expect I can make you know, I can't make every person that comes in the court feel I guess feel good about leaving. I think, I guess I take consolation, and I certainly did not. This person was concerned about the way I handled it. I also have to look at the highs and the lows, of the comments.
Right. So I guess maybe I just need to be a little bit more direct. I was trying to be as diplomatic as possible, but the reason that this comment spoke to me is because I've only known you in the context of this committee, and this is my third year on the committee, but I think you can come across as a little dismissive. And that has been my personal experience. You asked us to reflect on our personal experiences as legislators with your performance in the legislature. And so that's when I read that comment, that's what I read. And obviously you don't know about the personal experience of that individual person, but so that's what you don't have to answer it, you can think about it, but I think that that's one thing that as you learn from this process, and how you might come across to some people, that's been my experience. on a couple of occasions.
And I'm sorry that's been your experience, but I will tell you that whether it's your questioning tonight or any of the questions that are presented to me, this is always a learning process for me, as well as any judge that comes before you. So I take seriously and heart the question you've asked, and it's unfortunate that I have come across that way to you, and it still means that I have room for improvement.
Thank you. I appreciate that, Judge.
Thank you, Senator Hardy. So Representative Knott, we will move to you. You have some questions for the judge.
Thank you. Yes, Judge, you had mentioned when you can, obviously that's not right now, but when things before everything shut down, you had mentioned sitting in on different court proceedings. And first question is, when you did that, are you actually trying to make your way to the different courts throughout the state, or just particular divisions?
No, I go on what whatever the need is. In other words, when the calls or emails or requests come into the court, if I'm available on a given day, I will go. I don't single out a court because I want to sit there or single out a division. What I try to do is, if I would say, and I don't know that they're all reflected in the 18 months, but over the last whatever number of summers, I mean, I have sat in Lamoille Court, Franklin Court, Rutland, Brattleboro, St. Johnsbury, Barry, because it's nearby. So wherever the need is where I will go if I'm available to do it. So in those courts, I'll cover criminal dockets, relief from abuse dockets, civil dockets, but it's just a matter of where the need is.
Thank you. And then just a second question. So when you are working on judicial rotations,
yes,
and I'm thinking of assignments, are you factoring into your deliberations geographic justice, or do you feel that's something that is more of an issue in the prosecutors and law enforcement division, and not something that's it doesn't factor in as heavily with the judiciary?
Well, clearly the issue of geographic justice is one that we talk about almost every time we're in certain committees. But I'm not sure how that would come into play in rotation. That would almost be like I would be assigning a judge. I'm not sure how that would come into play. I recognize the issue, but I'm not sure that I'm not sure how I would see that coming into play with my decision.
All right.
In other words, if you're talking about geographic justice in terms of criminal docket, I'm looking for judges for the most part who are experienced in the criminal docket. Now, having said that, we have many judges, as I think you all aware, that come into the judiciary with backgrounds that don't lend themselves to the criminal docket. So it's not as if we're going to take someone who has never experienced that docket and put them into a sole criminal docket. We try to bring them along and get experience. But I'm looking for judges who have significant experience in a criminal background for the major dockets.
That certainly makes sense. Thank you.
You're welcome.
I'm all set. Thank you.
Representative Knott and Senator Benning.
Judge, I think it's probably grossly unfair to have you in the retention process having to deal with the frustration of those of us who are involved in the criminal justice system. But unfortunately, right now, you're the only one who's drawn the short straw for the position that you happen to be in. If we are waiting for physical plants to be brought up to speed to match a pandemic, I am deathly afraid right now that we are making a critical mistake, because it's not the physical plants that are going to solve our problem of moving forward. It's actually protecting the people that are in those plants. And the best form of protection right now is to get them vaccinated against this pandemic. So I'm going to put the plug in again that the judicial branch of government, even though it is moving, it is on virtual shutdown. As luck would have it, today I had 3 instances where that came right back to me. I began the day by getting a phone call from the mother of a kid who's been in jail for over a year now. They want to fire me because I can't get his trial done. And I look up at the ceiling and I say, please God, send the court a notice for me to be replaced. I just would enjoy that at this moment in time. But the next thing that happened was I received an email that was sent to the court in Orleans that was from the state's attorney, Jen Barrett. And she outlined all of the cases that have had documents filed and are ready for hearing that haven't been approached. One of which is a plea agreement of mine that was filed on the 2nd of February, and today is the 24th. That case is, I believe, a 2018 case. When you are dealing with calling a jail and the jail has one room available for video conferences, that happens to be the same room where the attorney line is when you're calling in to speak to a client. If that room is occupied all day for people who are going in front of the court, it's not available for us who have to work through making documents like plea agreements and getting people to sign them. So I'm going to put the plug in again. I really wish the judicial branch, and I'm not just blaming or trying to place the blame on you, but you happen to be the conduit right now for this message. The committee that is working on reopening the courthouse, I submit, has got to take the position that court personnel have got to be vaccinated as soon as possible. They should rise to the top of the list, because the judicial branch cannot move forward if the expectation is it doesn't move forward without an HVAC system being brought up to snuff. We don't have the money right now in institutions to bring all of our courthouses up to snuff. And if that is the triggering mechanism for getting these cases moving, I'm telling clients right now, if you're coming into me looking for a jury trial, you're at least 2 years out. And I don't think that's an exaggeration at all. In fact, I think it's probably on the short end, judging by just my file cabinet alone. But I really believe that the increasing cohort of people who are now getting vaccinated provides a potential pool of jury members that ought to be looked at, and we start the process of reopening again by using that cohort. I do understand defendants might have to waive some kind of an argument about a jury of their peers because everybody in the jury pool is over 65. That's okay. I have people who have been sitting in jail for over a year now who would love to have any jury, and the age doesn't matter to them. But it seems to me the first people that have to be protected are the people who are behind the desks when you walk in the courthouse. And I really would urge you to have that conversation and speak with Dr. Levine and the administration in order to get that cohort of people vaccinated as quickly as possible. My other question that I had has been answered earlier, but I was thinking here, listening to everybody else, was this actually a position you wanted, or did you in fact draw a short straw to get to be where you are?
Well, let's put it this way. I haven't had anybody beating down my door for my position. So whatever my thinking was that prompted me to put my hat in the ring, I've long since forgotten, Senator Benning, why. But as I said, no one is really pushing me to take my position.
I was thinking that if we sent out surveys to all of your fellow judges and they're not beating down your door to take that position, they probably would be skewed in their answers.
They'd probably say that I'm doing a great job because they don't want to be considered for it.
Right.
But I would welcome the survey. I think it would certainly be helpful to anyone in my position. So I could support something along those lines.
Okay. Mr. Chair, that's all I have. Thanks.
Thank you, Senator Benning. Most of my questions have been answered during this course of this session. I do have a few comments to make, though, regarding opening up courthouses. I've been just about to every courthouse in the state of Vermont at this point, on business, not anything other. And I guess I would suggest that when I think of that, the courthouse in Guildhall comes to mind, the courthouse in Grand Isle comes to mind, the courthouse in Hyde Park comes to mind, and even St. Johnsbury, which is a large building, but the courtrooms are totally inefficient as far as trying to put together something that you have described to us as safety. And just a quick follow-up, I had the court staff in mind as well, a follow-up to Senator Benning. The court staff has to be protected as well. So, it may be easier said than done. In addition to that, I take your comments about being here at the legislature to be considered by us, and that also struck a chord with me. My years on Human Services Committee, you and I and our committee had dealt with some pretty gnarly juvenile issues in which your advice was always sound and well thought out. So I certainly appreciate that, Judge. As far as rotation goes, in my years in the criminal justice system, judges were always traveling an hour and a half, 2 hours to get to their jurisdiction to sit on the bench. So that's nothing new. It's nothing that came about as a result of your appointment to this position. So, these are just things that came to mind. I've also, just to wrap it up, I've also sat in the courtroom when you were on the bench. And I always felt that you were attentive, that you gave the litigants a fair shake, and that you did a good job on the bench. So I just wanted to wrap it up with that. And that being said, I think we're done here with you, Judge. Unless you have a comment.
No, I don't. I would just thank you to all of you for your comments. I appreciate them, and as I said, I learned from them. I wouldn't want anyone to think in our goal to resume jury trials, criminal or civil, that every courthouse is going to have to use 3 courtrooms. I'm not suggesting that at all, but we do need to look at these buildings, and we've got to stand up the buildings that are available now to start moving some of these cases for the same reasons that Senator Benning said. And we're confronting that challenge, and we're going to get there. And I certainly am familiar with Guildhall and that courthouse, having spent my own first rotation up there many years ago. So I'm familiar with that, and I've sat in all the courthouses now. So I understand the struggles with the individual structures, and we're going to keep at it till we reopen safely and to respect the rights of folks that are being detained. So that's our goal. And I thank you for all your attention and questions.
Okay. Thank you, Judge. Appreciate your candor. And we will turn to Judge Waples. Welcome, Judge. And if you have a prepared statement, we would like to all hear it.
All right. Thank you. And good evening, Chairman Triano and members of the Judiciary Committee. Thank you for this opportunity to share with you my hope in continuing to serve Vermont as a Superior Court judge. I have spent my career as a trial judge, trial attorney, and appellate attorney. As a lawyer, I primarily practiced as either a prosecutor or a criminal defense attorney in both the state and federal courts. Because I am accustomed to arguing both sides of a case, I have learned that most cases have strengths and weaknesses. As a judge, this has taught me to be fair and open in my judgments. Law for me is not partisan, and I am deeply committed to the rule of law. I love my work as a Superior Court judge because it allows me to perform justice in individual cases. That has given me the opportunity to learn other areas of the law and to work in different courthouses throughout Vermont. This has been exciting and deeply rewarding. Currently, as presiding judge in Lamoille County, I am fortunate to hear cases in the criminal, juvenile, family, and civil dockets. I also work with the clerk, courtroom operations manager, staff, and stakeholders to manage all the dockets. Deciding on protocols, conflicts, and resources while managing a courthouse has been extraordinarily difficult during both a pandemic and the judiciary's transition to an electronic management system. Nonetheless, when making those decisions, my goal is to reach consensus. It is important that all stakeholders who are affected by the court's decision know that the court has listened to and taken their positions into account. Every day, I strive to treat with dignity and respect every individual who comes into the courtroom. I am committed to making sure parties feel heard and, regardless of the outcome, leave the courtroom feeling they have been treated fairly. I am proud if those who have appeared before me have that same perception. I am deeply grateful for the growth this job has given me, and I believe I have worked hard to meet the challenges. When I reviewed the survey results, I was disheartened if anyone who appeared before me felt I lacked the proper temperament, commitment, or fairness to be a judge. No judge should ever leave that impression. This process is a critical reminder of the importance of public perception and that I must work harder so that each person who comes into the courtroom leaves with a positive impression of the judicial process. I am enormously proud to be a member of Vermont's judiciary. I welcome the constructive criticism. I consider myself a work in progress and see this process as an opportunity to grow and do my job to the best of my abilities. Currently, I serve on several committees that focus on policy work and strategic planning within the Vermont judiciary. This work has been quite rewarding as it has given me a broad perspective of the judiciary that is complemented by my day-to-day experience as a trial judge. It has helped me to identify and strive towards addressing issues to promote the fair and efficient administration of justice in Vermont. Our judicial system is charged with ensuring equal justice under law, a pillar of our democracy. It is critical that every person has equal access to justice. As Vermont becomes more diverse, so must our state's institutions keep pace with those changes, especially our court system. Having learned English as a second language, I know that language access can be a bar to justice. As a minority, I understand firsthand the challenges faced by a diverse population. As a judge, I have presided on the interpreters block in Chittenden County, working with the Vermont Bar Association. I created the diversity section and served as its first chair. To develop policy and programs to help address issues faced by minority populations, I serve on the judiciary's language access for the courts committee and the governor's racial equity advisory panel. I have called Vermont home since 1991, and I have witnessed with pleasure Vermont's increasing racial and ethnic diversity. My life has been enormously impacted by growing up in two very different cultures. My parents fled the communist revolution in China, and due to exclusion laws here, were unable to immigrate to the United States. Instead, they made their way to Chinatown in Toronto. When exclusion laws were replaced by ethnic quotas, only my father could immigrate to the United States. We were separated as a family for 4 years. When we reunited, my family worked side by side to earn a living in our small Chinese restaurant outside of New York City. I believe I bring a different personal perspective to my role as a judge. Of course, a judge's legal decisions depends on fact and relevant case law, not on personal viewpoints. However, justice does not come just out of law books. Its inspiration is the individual spirit and the human soul. 6 years ago, when I was sworn in as a Superior Court judge, was one of the proudest days of my life. My late mother, who came up to the ceremony through a snowstorm, was equally proud. But with characteristic immigrant reserve, she reminded me not to take myself too seriously. Remember, Nancy, she said, you work for the people, work hard, and don't let them down. I try to heed my mother's words every day I sit on the bench. I am not always successful, but every day is also a learning experience for me, and every day gives me a new opportunity to grow and develop as a judge. Like everyone, I can learn from my mistakes. Thank you, and I welcome your questions.
Thank you, Judge. So let's see, we can start with Senator Hardy right at this point. Would you like to question the judge?
Sure. Thank you, Mr. Chair, and thank you, Judge Waples.
Welcome.
It's nice to meet you for the first time, and I was a couple of things that struck me, and you can react if you want, about your, I would love to hear a little bit more about your work about translation services. I think that's something that we're behind on in Vermont, because we make the assumption that it's not necessary when obviously it is necessary. So I'd love to hear your thoughts more about what the judiciary and the court system can do to improve in that area. And then just a couple of comments. I was fascinated by your decision where you spoke about whether or not it was an actual search and whether putting a key in the door. I loved that. That really showed how you pick apart the puzzle of a case. And that's what I think when I referred to, we missed that with Judge Grierson's not having that ability to read his cases. So I appreciated to learn how your mind works, I guess, in a way. And then wondered if you could react also to, there were some comments from DCF in particular, and wanted to hear your thoughts about that.
All right, thank you. Thank you very much, Senator Hardy. Let me begin with the Language Access Committee. So I think it is very important that as our population becomes more diverse, and English is the second language for many of the immigrants who relocate here, either through the resettlement program or through other processes, that we have interpreters who are trained interpreters in the courthouses, that we have forms, the most commonly used forms should be translated into different languages, so that a petitioner who files for an RFA will be able to understand how to fill that out without having to find somebody to interpret for her, because certainly in the after hours context, there may not be an interpreter available, and they would have to try to find somebody who is family related to fill that task. So I think that those are very critically important aspects of the judiciary that we have to improve on. In terms of, would you like me to answer any more questions as to that issue, Senator?
What about during an actual case or
Sure.
litigation and having an interpreter available to someone?
Yeah, so that I think is why it's very important to have trained interpreters either on premises in areas where there is a larger ethnic population. For example, in Chittenden County, Chittenden has addressed that with an interpreter's block. I tried several cases with interpreters, but oftentimes we are the only interpreter available. It's only one day, I think, it's been several years since I've rotated out of Chittenden. And and Judge Grierson can correct me if I'm wrong, but I think the interpreter block may only be twice a month in Chittenden. And there is an interpreter who will translate for hearings where it's there are substantive issues. Certainly for a trial, the judiciary will hire interpreters to be present during the trial. But other proceedings that are non-evidentiary, the interpreter is by telephone. And I can say from my own experience that because I cannot make myself a witness, there have been times where I have had an interpreter translate in Chinese, and I wasn't quite sure that that was what the translation said. So in any event, but those were all non-evidentiary proceedings. Those were kind of pro forma status conferences and sometimes arraignments when there wasn't contested conditions of release at stake. Because in those circumstances, then I think I would have to recuse myself and request that there be another interpreter or another judge sitting on the proceeding.
Oh, that's interesting. And is there specific training for judges to hear cases or trials that involve an interpreter? I would imagine that
there is not. And I think that's a very good, I think that's a really good suggestion that I will bring back to the committee. I think that's a very good suggestion.
Yeah, because as someone who I'm not fluent like you in another language, but who knows enough to be dangerous in another language, like how do you interpret that as a judge, and what are you supposed to hear, not hear, and how do you work with an interpreter? I think that would be helpful. So thank you for that. And then just your comments on the DCF comments in your evaluation.
Okay, so you went out a little bit on me. Can you hear me, Senator?
I can. Can you hear me? Yeah. Thank you.
To make sure. So I was I was disappointed by those comments. I strive to be fair and to listen. As Judge Grierson said, one of the most important things we do is listen, and I strive to listen to all parties. And in juvenile cases, there's multiple parties. In addition to the attorneys, there is the DCF, there are guardians, there could be, if they have standing, foster parents. So I can say that I have been a former state prosecutor, federal prosecutor. As a state prosecutor, I worked in the domestic violence unit in the Manhattan District Attorney's Office. As a federal prosecutor, I was assigned the Project Safe Neighborhoods Coordinator, where our initiative under the U.S. Attorney was to prosecute domestic violence cases that had a gun component. And I've been a defense attorney. So I like to believe that having that experience, my temperament is fair to both sides. But what I can say is very different for me. Now, as a judge, is this opioid epidemic that is ravaging not just our juvenile docket, our family docket, our criminal docket. It's really become something that is really overarching in so much of the work we do. And I believe very strongly in the imperative under Sandowski versus Kramer, the U.S. Constitution, the U.S. Supreme Court case that constitutionally gives parents the right to raise their children unless they are, by clear and convincing evidence, at risk. And I think a lot of these parents whose children end up in DCF custody are dealing with so many stressors. They are dealing not only with housing, joblessness, they are dealing with, some of them is dealing with extreme poverty, especially in the more rural areas like Lamoille, where I sit. I believe that given those circumstances, I understand that sometimes they might need a little more time to get all the services in place or to completely engage in those services and to embrace those services. I always encourage them to embrace those services. And if I feel that the parents are able to rise to that challenge and they will get there, maybe not on the fastest timeline that the case plan may call for, but I believe in modifying that case plan if I can get parties to agree. And I see from the parents that they do want to raise their children. I can say that of the cases in which I have, if I see a child is clearly at risk, I am not going to, it's obvious to me that I'm not leaving those children or that child in with those parents, and I will put them certainly in a safe place. But I've had two cases that have gone up on appeal on a CHIN's basis. One, I was reversed after I found CHIN's. And then the second one, I was reversed because I found CHIN's for mother. I was affirmed for finding CHIN's for mother, but reversed because I believe father didn't have notice, adequate notice, and that he should have been given more of an opportunity to comply with the case plan. And on that case, I was reversed. But that's the only way I can answer that, Senator. I don't know if that satisfies your inquiry, but I'm happy to explain more if you'd like.
No, I think that's good. I think it shows your perspective and why DCF may have felt negatively. So, but I appreciate your honesty. I really do. So thank you.
Okay, thank you.
You're muted, Chip.
We'll call on Representative Colburn.
Thank you. I just want to say I really enjoyed reading your materials and
thank you.
Your personal story and how you reflected on it, just your life and your history and how that impacted your work as a judge. And also
thank you.
Found your work on diversity, equity, inclusion, translation services in our courts really inspiring and very much needed. So it was just a pleasure to learn more about your work. And I guess the question I had was, you had some of the just strongest comments I've seen in these dossiers, and then a few really outlying comments, which I think actually is, I've also seen that's not uncommon in these survey responses, but I'm wondering if there was anything that resonated with you or that you took to heart or that you had in some of those outline comments, or if you did just think, wow, I have no idea what that person was experiencing, or was there anything there that you kind of reflected on and thought, yeah, maybe I could do something differently?
Yeah, well, thank you for your nice comments. I really appreciate that, Representative. I certainly can't speak to why someone has a particular perception. I can say that if somebody feels that I have been disrespectful or that my tone was unwelcoming, then that's something I have to work on. I mean, I think one of the comments said that every time someone comes into my courtroom, I acknowledge the litigants first. I think I always do it without exception. I always acknowledge the litigants before I acknowledge the attorneys or anyone else. So I'd like to set a welcoming and warm tone to people. I know how terrifying a courtroom can be, and I want them to be comfortable. I want them to know that this is their courtroom and not to be afraid of the person sitting on the bench. I'm troubled if people are afraid of me. There was one comment that about all the status conferences and continuances. I don't know where that perception comes from. I mean, I can tell you that one of the things that I learned many things from Judge Grierson. And one of the, I think, most valuable pieces of advice that he gave me was in certain cases, the misdemeanor cases, for example, there should not have to be so many status conferences. And that is something I do not do. I think this person made that comment about all the status conferences. At the time of arraignment, I will ask the prosecutor, have you conveyed a trial offer or have you conveyed an arraignment offer? Often they have, because they know my practice. Have you turned over the discovery? And if those answers are yes, then I will set a motions deadline, and I will give them a deadline on when they file their motions. And then if I hold an evidentiary hearing, I will give them notice. The clerks will give them notice of when that hearing will be set. And then regardless of whether the decision at through the motion is dispositive or not, then it either gets set for trial or for a change of plea. And I think that same comment said that I will often take a change of plea in disregard of the victims. I can't do that, first off, because if I have a prosecutor who tells me, Judge, we have to consult with the victim, I know the victims have to be consulted. And I would not do that. I don't know, again, what their perspective was or what they may have observed. But I was very troubled by that. Nobody likes to see the adverse comments, but as again, I embrace that through this process. This is my first real time. The last time when I went through retention, I hadn't even been sitting on the bench yet. But this is an opportunity for me in this forum to really learn how to really work harder on my job. So that's the best comment I can give you. If somebody felt that way, then I will endeavor to make clear. Perhaps I didn't make clear on the bench what I was doing, and I will endeavor to explain it better. Or I don't know if I answered your question.
Yeah, no, you did. That was really helpful. Thank you.
Thank you.
Thank you, Representative. We'll call on Senator Benny.
Judge, I had my internet cut out on me for a few minutes there, so if I freeze up somehow, hopefully I'll get right back on.
All right.
I didn't see anything in your comments about people who were affronted by your activity. I did notice two comments that some could deem as negative. One is that you favor defense attorneys, and the other was that you favor male attorneys. Now, as a criminal defense attorney who's male for 37 years now, I don't necessarily myself see that as a bad thing. But we on this committee should ask the question, what is your thought in response to that?
So my thought in response to that was, I never want any attorney who comes into my courtroom feeling that I have a chummier relationship with their adversary. I always strive to treat both sides equal, acknowledge both sides. If I have made another litigant feel that they were less important or less welcome in the courtroom, for that, I apologize. My only explanation I can think is, having been a practicing attorney for 20 years and an older person who went on the bench, I might have had some personal relationships, or not personal relationships, but professional relationships with some of those attorneys, and may have said, "How are you? How is your children and so who may be in college or not, or working locally somewhere." I may have had those conversations and made another attorney feel that I had maybe a special relationship with the other attorney. And if that's the perception, again, I do not want that to be, I don't want any attorney to ever think that. So this process helps to tell me that that's just not the appropriate thing to ever do. I don't think I do it all I don't know if I'm not really cognizant of doing it all the time. I don't think I do. In terms of favoring male over female attorneys, I don't believe I do. I think I'm just as strong an advocate for good lawyers, whether they are males or females. What matters to me is their preparation and their advocacy for their client. And again,
I appreciate that.
So if any female attorneys feel that I have not treated them as the same way I would a male attorney, then that's something I certainly have to work on, to not let them have that perception.
I appreciate that. And let me close out with you by saying, with respect to your opening remarks, I personally found them to be a model of humility and self-reflection that I really believe I'd love to hear from every single judge who comes on before us. So I appreciated your opening remarks.
Thank you very much. Thank you very much.
Thank you, Senator Benning. Move to Representative Knott. Do you have some questions for the judge?
Thank you. Actually, the questions I have already been asked. I will just say that this is my first year on this committee, and I have to admit, when I took the assignment, I did think it was going to be a bit of a slog. And reading your material, reviewing it, it was just fascinating, and it was inspiring. And so I just wanted to note that. But the questions I did have, which were related to language and interpretation in the court, were already asked. So thank you.
Thank you very much, Representative.
Thank you, Representative. Senator Nitka, would you have some questions for the judge?
I just would like to say that, again, I appreciate all the work you did putting this material together, but I think your level of work and in-depth, like the cases and the decisions that you wrote were, of course, very well done. I do wonder how time to take to write some of the decisions and get in all the details that you were able to do, which, were excellent. But I'm wondering, with your schedule, with all the courts that you're in, and the filing system being apparently a frustration for many people, how do you manage to get enough done, or is that a problem to get all in that you try to?
Well, thank you for that question. I really appreciate that question. And I do have to say that it is really sometimes it feels like a Herculean effort to try to manage the time. I prioritize, obviously, based on detained defendants and get their cases moving as fast as possible. But I am very fortunate that the staff has always been very supportive, and they will oftentimes will remind me if I am a little behind in something and I should get moving on that, and that's great. This year has been I had the additional challenge of a 2.5-hour commute round trip from where I live in Heinsberg to Lamoille to Hyde Park, but I'm not complaining because, as I said, this is the most beautiful state, and I do think it's a privilege to be able to work in different parts of the state and certainly get to serve all the different members of our community. But I think something that would help would be to have extra law clerks, because oftentimes I will find that I'd like to issue a decision, but I'm not quite sure whether or not I'm right on that area of law, and I want to be accurate so that I can obviously issue a decision that is based on the law and hopefully gives the parties finality so they don't have to worry about an appeal, or I don't have to worry about it. I don't worry about appeals. One thing about appeals I've learned is that, like this process, it will teach me to do my job better. If so, but it is a balancing test, and I think that for a lot of women, professional women, you learn how to balance when you're trying to raise a family or have a career, and that's the same for men too now, which is great, I think, for everybody.
With regard to that, do you think there's, you're at a lot of meetings with the other judges and, of course, with Judge Grierson and I don't know about the Supreme Court justices, but trying to get some more law clerks, because it does seem that everybody is really overextended, even though everybody is able to continue to do their work. But it seems like that is a real need. And is there a possibility for pushing for that to happen? I don't know. Is that?
I certainly would love to do anything I can to help in that regard, whether it be through the judiciary or any other avenue.
Yeah, certainly a very good issue to raise. So that's. I think I had one other thing, but I'm good. So thank you very much. I'm really happy that you like the job, and glad that you came here and are doing it here. So thank you.
Well, it's my privilege. Thank you.
Thank you, Senator. Representative Shaw, you have some questions for the judge.
Thank you, and I do. So I appreciate the time, and so Judge Maples or Waples.
That's okay. That's fine.
It's stuck in my head there, and I apologize for that.
Don't apologize. It's fine.
Okay. So I did enjoy reading your declaration of candidacy. I felt it was a chance for me to get to know you a little bit, and even though I never met you before, but I came away with kind of a feeling that, this is somebody that I love to talk to and hear from and get to know you. And I appreciate the time you spent writing that. And it was in my opinion, it was well written. Surveys are surveys. We know that. And I'll get to my question here. So sure. Surveys are surveys, and we know that. But I take a little bit of extra attention at the non-attorneys piece of the surveys. And I was not concerned because it's one opinion, but you were described as inconsistent and frequently late. And I hope you can comment to me on that a little bit.
Sure, I will. The inconsistent, I think, and again, I don't, it's on my computer, but I think the inconsistency was in terms of ruling. Is that correct? I think that was, and yes, okay. Well, again, I'm not sure the context of what that person made the decision or made that observation in, whether it was in when I was imposing conditions of release on a case where they thought perhaps it was similar to another a case, or whether, so I'm not sure there, but that having been said, I follow the law. And if I am required to do something procedurally, or because the law directs me to do that, then I will do what I need. I will uphold the law. I think earlier in my remarks, I said that I firmly believe in the rule of law, and I do. And I think that there are lots of different overtones and situations, perhaps, where what a judge does may look inconsistent, that the judge did this in one case. And what I'll use as an example is perhaps in a case where a defendant is charged with domestic violence. Without exception, I will impose conditions of no contact to protect the victim, and feet restrictions so that the defendant doesn't come within a range of the victim and her home, her car, her place of work. There are times, however, when the prosecutor and the defense agree to contact because the parties want contact, but they'll want a no abuse condition rather than restrictions without contact at all. And if the parties agree and they tell me why they want that, then, and I feel that the victim is safe, then I will take my direction then from the prosecutor and the defense attorney and impose that as a condition. So those are kind of cases where I have to look at everything individually. There isn't a one size fits all in my mind as a judge. I can't make one size fits all decisions. There are just too many variables in the people who come before me that I can't impose the same thing all the time. I think that's one of the roles of a judge, and those are the difficult decisions that you have to make. The other statement about being late all the time, I don't go on the bench until my court officer tells me that that they're ready for me, and I am at the courthouse always at least a half hour before the docket begins, and the attorneys may be talking amongst themselves and they're not ready. And so what I prefer is the court officer get a sense from the attorneys whether or not they have come to some sort of a decision, or at least something that will advance and move the case. What I don't want happening is to get on the bench at whatever time the docket begins and have lawyers say to me, "Judge, we're not ready. We haven't had a chance to talk. Can we take a recess?" I just find that is just not a efficient use of judicial resources. So perhaps it gives the impression that I am late, but I can say that I'm not late. I don't get to the courthouse after the schedule, the calendar begins. So.
Thank you for both those explanations, and I appreciate you answering those questions. And thank you, Mr. Chair. I am complete.
Thank you.
Thank you, Representative. Senator McCormick, you have some questions for the judge.
Thanks. Although this has changed in recent years, it used to be in the Senate that showing up late was a prestige thing. It showed how important you were, that everyone had to wait for you, but that has changed recently.
That's never been my motive. That's never been a motivation for me.
I had one colleague who literally would wait in the hall to come in just so she could make an entrance. one of the most troublesome things I find pertaining to the courts is DCF and family child abuse. And one of the problems for a legislator is that these cases are properly, as they should be, confidential. There's a lot, DCF doesn't talk to us about them. Usually if I get a complaint from a citizen, I call the appropriate administrator and we talk about it. In this case, the answer is, well, Senator, I'm not at liberty to discuss it, which is as it should be. But that means I don't know what's really going. You have a clearer view of this than legislators do. I know that half the complaints I get is that overly zealous bureaucrats don't respect families, and that it's often class prejudice. And the other half of the complaints I get is these kids need protection. They deserve protection. Where the hell is the state of Vermont? And again, I'm in the dark. I do know that one way or another, you as a judge are having to choose between something awful, taking the kid from the parent, denying the parent the kid is awful, leaving the kid in a vulnerable position where the kid might get beaten up or worse is awful.
Yes.
So how, and also one thing I actually am convinced of is that probably a lot of times the families, the children's lawyers are overworked. They're public defenders and they're overworked and they have too large a pile of cases. How do you handle DCF cases, CHINS cases?
So, obviously, if once the petition is filed, I often find in the CHINS cases that once a petition is filed, the DCF worker will have already made attempts to talk to the parents and put services in place for them. And if those parents, I always hope that parents will embrace those services. Sometimes the services may be overwhelming for the parents. I think especially if you did mention, Senator, that there are some economic factors oftentimes that the parents may not be able to have the children in all these therapy sessions or meetings, or the parents can't because they just have to work jobs where they can't take that time off. So I look to the services, and oftentimes at DCF it's wraparound services, which I admire and I respect and I appreciate that they're trying to put in place for the parents. But then I also have to take into account the reality of these parents' lives. Are they struggling to stay in their jobs because their jobs pay less than minimum wage and they don't have the luxury of being able to take all this time off to attend meetings or to bring their children to therapy sessions because it's recommended through a program? I hope they can do it. I think my view oftentimes is to give them the benefit of the doubt and give them more time to achieve those goals. For example, under a case plan, if there isn't a desire to take the children away immediately and put them into foster care. If those children are in foster care because I've seen that there's danger to those children, then that's where I think the children should be. And I think DCF has done a good job then recognizing those issues and the potential for further abuse. And or the parents will make an admission. If it's not in a contested merits hearing, they make the admission then, and they agree that their children can stay longer in DCF custody so that they can get themselves into a place where they can reunite with their children. It's just a tremendous amount of balancing and faith in human nature. And the I think, the inexplicable, well, hopefully the extraordinary bond between a parent and their child, and a parent wanting to raise their child. If, however, there is any danger to that child, to the children, then in those circumstances, I am not reluctant to do what the law directs me under, 33 VSA 5114A, and that is to find by clear and convincing evidence that the children are at risk and have to terminate their parental rights. It's without question, though, one of the most difficult things a judge has to do, in my mind.
Yeah, I fear I've done you a disservice even by asking the question, because I don't think there actually is a good answer you could possibly give. It's an impossible situation.
Well, it's a good
I'm
question
asking
to
you
make
really,
you
how
think.
do you-
Well, it's a good question to make you think
Yeah.
about your job. So
How do you
thank you,
handle an
Senator.
impossible
Yeah.
situation? Okay, well, thank you.
Okay.
That's all.
Okay, thank you, Senator. So I just have a few questions and comments, I guess. Well, more comments. The language piece, well, first of all, I enjoyed your story. I'm really happy to see you here today, Judge. It's really
Thank you.
a great and
Pleasure.
story. On the language piece, when I was working in the criminal justice system, well, I recall one interpreter, a Quebecois woman who up in Orleans County, we would call in to interpret, until we found out that she was kind of interjecting her own thoughts and theories into her interpretations. So we stopped using her. And then there was a phone. The last I remember, there was a phone service that would supply interpreters by phone. Is that still available, Judge?
It is still available, and it is typically used if a foreign language speaker isn't going in an arraignment proceeding, for example, in the interpreter's block in Chinden, then there will be a telephone interpreter who has to, of course, swear that they are translating accurately and understand that they're translating for the judiciary.
Okay, I do recall a case that, in particular, was a Chinese dialect that we could not find anyone who spoke it, and presented some difficulties in court.
Well, I don't know if was that before Judge Pinellas? Because I was an attorney in Judge Pinellas's courtroom, and they had a Chinese defendant, and the wrong interpreter was the wrong dialect for the interpreter was brought in, and I actually did that translation. So I don't know whether he asked me if I could do the translation, and I did, and I translated for someone else's client.
Then Judge Pinellas. I mean, I worked with Judge Pinellas. So one of the other things that I wanted to comment on is that I can see how your position on conditions of release in domestic violence cases would draw some criticism. But, in my years, again, in the business, sometimes it was not ever considered that that when a defendant is removed from the household, it can set the family in financial straits that are really become critical, especially families with children, that all of a sudden they're calling me up and asking for conditions of release to be modified because they can't pay the rent, they can't pay the phone bill, they can't get their medication, the kids need new boots. I mean, all these things that happen. So, I respect your position on that as to being someone who will consider sometimes, as we find, unpopular decision that can respect and to assist in that type of situation. And I guess I would close out in some of the things that you had said, Judge. Your marks are really pretty good, and aside, as Representative Colburn said, aside from a few comments, they're all they're pretty pretty good accolades, actually.
Thank you.
But you told us that everyone in the court should be treated fairly and listened to. And then you moved on in some of your comments that you need to, when you hear these things in a forum such as this, that you know what you need to work on, and you know what you need to do better. So in my years on this committee, we have seen criticisms of some judges, which were fairly strong, and some that were really good. But that's what I consider on this committee to be that would be the ultimate in being considered by a judge who appears before us for retention. Those are the issues that we need to hear. Those are the opinions I should say that we need to hear. And I was happy to hear you put them forward. So thanks very much for your.
Thank you very much, Chair Triano.
So no further questions. Eric just appeared. So I think that will conclude this hearing. And I think